So I want to briefly introduce to you our sponsors for today. So Navigate Small Business is a joint initiative between Grenfell Campus and CNA Corner Brook Campus. Navigate offers free support to entrepreneurs, including end-to-end startup services from coaching, tools, training, mentorship, access to resources, funding, programming, events, and networking opportunities. Navigate's manager, Allison Rowe, who's not able to join us today, but she is available. She's only an email away, so I'll make sure I post her contact information for you all. And this is brought to you in partnership as well with CBDC NORTIP. We're delighted to partner with CBDC NORTIP, and CBDC NORTIP is one of 41 community business development corporations operating in rural Atlantic Canada. The CBDCs are a network of not-for-profit organizations that work in cooperation with all levels of government and the private sector to meet the needs of small business. So as I mentioned, a couple of housekeeping items. As I mentioned, this session is being recorded. So we ask that you keep your microphones muted if you're not speaking. If you have any questions while Jacqui is presenting, she will gracefully hand over the microphone, the virtual microphone, to you. If you don't feel brave enough to talk, you can put your question in the chat and I'll keep an eye on that. Also, this is extremely important. After today's session, I'm going to be sending you an evaluation form, and we ask you to please take 8 minutes of your time. That's how much the system told me it should take you, to let us know how this went for you, and for you to let us know what other sessions would be beneficial to you. Without your feedback, we would just be guessing as to what would be helpful for you and your business. And we want to make sure these sessions are relevant. So I don't have any other items. So I'll pass it over to you, Jacqui.
So thank you for coming and thank you for having me. It's always my pleasure. I do several of these throughout the semester, and everyone's a little bit different, and I try to think about my audience. So I was thankful that Mary sent me the list of people who would be attending. So I tried to structure my presentation in a manner that you will find useful. But the most you will get out of this is if you talk to me and ask me questions and we have more of a chat than you have listened to me do a boring presentation. So please, if I spark a question or if I spark a further discussion about something that you're interested in, now is your chance for free legal advice. And I say that in jest, sort of, because I have to say this is not really legal advice. It's for your information only, because I am a practicing lawyer and I don't want to be liable for giving you advice in front of 20 people and it's all recorded. Having said that, please fire away at your questions and I'll do my best to help you. So a little bit about myself. I work with Ken. I survived 10 years working with Ken and I still love him. And I love being home. I'm back in Corner Brook for the moment. And I'm from Corner Brook and spent a lot of my years helping to develop Navigate, and it holds a very dear place for me. But I have moved on and I am now directing, and I've created a law clinic with the law students at Dalhousie. And we support small businesses from a legal capacity. And my area is technology. But the basic legal issues apply whether or not you consider yourself a technology firm or not. So my presentation is based on my experiences, and I've been practicing for far too long, over 20 years. I know I don't look it. Thank you for thinking about that, even if you didn't say it. But I have been around a bit, and I'm happy to answer any of your questions. I certainly don't know everything and don't ever want to, but I can probably answer your questions or find an answer for you. So please feel free to talk to me. So it's supposed to be sort of workshop-ish. So the way I'm doing my presentation, I'm kind of asking questions out loud. And then I want you all to consider them from your own business perspective and what these questions mean for you. And I'll give you some examples of how I would answer the question or how I would think of the question. and then maybe that might spark you to ask a question or even think about your own circumstances. And when I do these, I always offer, if anyone wants to speak to me after, to just kind of follow up on some of the things I said, or to spend a half hour. I'm happy to talk to you on a call, answer any of your questions. So feel free. I'm sure Mary has my contact information. And if you feel like sending me an email just to follow up, I'm happy to do that for you. So I should start, but I told you I'm in the technology world. So my kind of personal area of interest is intellectual property. I haven't geared my presentation too much towards that. I think I have a slide on it because I'm not sure you have a great interest in learning about that, but always please ask those questions if you think I'm not going into enough detail. Oh, thank you, Mary, for sharing my contact information. I'm going to be sorry I did that, aren't I? Okay, here we go. So, and I say 10 legal issues, but honestly, I just kept making slides till I ran out of things I wanted to share with you. So I suspect there's more than 10, but let's go and see what we find together. Okay, so let's start. What do you want to be when you grow up? And I ask this from a business perspective. If you think about the business that you now have, whether you're in your very early stages or you've been a year in, 2 years in, 3 years in, you need to have a vision. What does that vision mean for you? And that vision results in different business structures, which have different legal issues arising from it. What type of business do you want to be? Do you want to be a social enterprise, a for-profit, a not-for-profit? Do you think you might incorporate? When should you do that? Do you really want to grow? That's a certain type of business. Or you're happy with a lifestyle, or do you want a bit of both? Will you need outside investors? That also creates some legal issues for how you set up. So these are just some things that I think about when I think about what I want my company to be when it grows up. I'm going to talk to you a little bit about the different types of business structures and some of the things that I see when I meet with clients, and a little bit about social enterprise. And I'm just gonna ramble on and tell you some stories and talk to you about some of these issues. But I want you to be thinking about your own company and kind of what you think where you want it to be and what you want it to do. So there are 3 basic types of businesses. One's a sole proprietorship, and that's where yourself and you're the only people in your company. You can have employees, but in terms of ownership, you own the company, you run the company, you make all the decisions. And then there's a partnership, which is 2 or more people running a company together. You may not intentionally try to be in a partnership, because I'll explain why that might be problematic in a second. But it's when 2 people kind of run a business together. Whether or not you formally create a partnership or register as a partnership, you may be deemed by the law to be in a partnership, because you can't be a sole proprietor because that's only one person. So you might be in a partnership just by the nature of 2 or more people working together on a business. The third main type is a corporation, and that requires a formal incorporation process, filling out forms, filing with the registry. And that would be the one where there are shares, and your business partners, so to speak, are shareholders that own the company with you, most likely. So those are basic 3 types, and there's variations to each, but let's just stick to the basics. There are pros and cons to each. There are pros and cons from a business perspective, from a tax perspective, and from a legal perspective. So let me try to tackle each of those if I can. A sole proprietor is one person. The sole proprietor, being yourself, being your own boss, having to report to no one, being able to do what you want to do without the formalities, without any kind of structure, is a lovely way to start your business. And these would be suitable structures for very low risk companies. People who just want to tinker at things and don't really want to get into any major money, but just want to kind of have a side hustle, or sometimes a home-based business might be okay as a sole proprietor. And the benefits of that is, like I said, you don't have anyone to answer to. You can just do what you want when you want. You don't have to register anything or pay fees. But the big downsides to that, you are alone. It's only you. You don't have anyone to run your problems past. Whatever money you make is claimed on your personal tax bill. So you can't use a corporate tax rate, which is very favorable in Canada right now. You would have to use whatever tax rate, whatever your personal tax rate is, and it would go on top of any other income that you have. And that could be a very high tax rate if you make decent money. And it's also not a mechanism for growth. It's really hard to grow a sole proprietor. You can have employees, but you can't promote anybody. You can't you can't bring on a partner. You can't bring on a shareholder. It's hard to grow. Investors don't like sole proprietorships. They don't like investing in a person. They like investing in a company. When you're a sole proprietor, you can't separate the two. So that's the basic form, the sole proprietor. The next form, which seems basic as well, but can have many legal complications and mostly with respect to liability. I'm going to touch on the liability in a second for all three. But if you're in a partnership or deemed to be in a partnership without a partnership agreement, you're governed by the Partnership Act. The Partnership Act has all kinds of funny rules that if you're not familiar with them, you could find yourself in a bit of a situation. For example, the Partnership Act claims that partners automatically split the profits 50-50. You and your buddy may have decided that you're going to do 80% of the work and your partner's going to get 20% of whatever profit you make, but the Partnership Act says otherwise. So another example, if there's three of you in business and you're deemed a partnership and one of you leaves the partnership, well, the Partnership Act says that your partnership has dissolved because all parties have to be present. So you have to be careful if you actually mean to be in a partnership that you formalize it properly and enter into a proper agreement to do so. What else about partnerships? One of the main reasons why sole proprietors and partnerships are problematic is the legal reason, and it's based on liability. So the sole proprietor is the same as the person. There is no separation legally. So if you have a sole proprietorship, you have a home-based business, someone's coming to your home to pick up crafts that you made for them in your sole proprietorship, and they slip and fall coming up your stairs of your home because it's slippery. They can sue you. And they don't sue your business. Well, they do sue your business, but it's effectively the same as suing you personally. So without the formality of a corporation to kind of hide behind, if you want to look at it that way, you could be personally liable when you have a sole proprietorship. Likewise, for a partnership, there is no entity to kind of hide behind, so you become liable. But even more importantly, as partners, if one partner does something wrong or negligent, or for whatever reason you end up in a liability situation, the other partner can be automatically liable for what you do. So I always use the example of two 18-year-old boys starting a summer job and washing cars and detailing cars, and one of the partners decides to take one of the cars that comes in to be detailed, take it for a spin, has a car accident, hurts somebody, on and on and on. Then the other partner who's not doing the bad deed, but happens to have more money, is the one who gets sued, because you're gonna sue the party that has deeper pockets. So those can be interesting situations to find yourself in if you don't realize legally what you're in for. So the solution to the liability issue and some of the other issues is to incorporate. And a lot of people are nervous about incorporation. They think it's very formal. They think it's very scary. They think it's very expensive. They think it creates a whole new level of administration. So I would agree with the last part. There is a level of administration, but it's not scary and it's not expensive. And sometimes it's the best way to go. And I get a lot of questions about when do I know that it's time to incorporate? So here's what I'm going to say. If there was an accountant on the call or I was co-presenting with an accountant, which I have found myself doing from time to time, we disagree on the answer to this question, and that's okay. So I would say that if you run a risky business, and we're going to talk a bit about risk in a little bit, if you run a risky business, and that doesn't mean you're doing something that's not good, it just means that the potential for liability is high. An example I often give is if you're having a home-based stationery store where you're making homemade paper and you're mailing out the product, you're probably okay as a sole proprietor, unless your customers are coming onto your property, and then I would definitely be concerned for you for that. But if you have a home-based tattoo parlor and you're sticking needles in people, I would recommend you incorporate. It has nothing to do with the size of the business, the potential revenue of the business. It has to do with the risk. So I would keep that in mind. If I notice some of you have restaurants, not incorporating a restaurant, you could possibly find yourself in a bunch of situations that you have risk. And we could think about what they are, and I'm sure you're thinking about what they are right now. But those are probably good ideas for good company ideas, good business ideas to incorporate. The timing of the incorporation, accountants would tell you, as a general rule, to wait until you've grown your company to see if it's going to grow before you incorporate. And I do not disagree with that, except for what I said about if you're in a risky business, you probably want to incorporate sooner rather than later. It's not a bad idea to see if your company is going to create any kind of traction in the market before you go down the road of incorporation. It's not a bad idea. However, and there are some complications with waiting to incorporate in terms of transferring assets into the company and some tax reasons, but in general, it's not a bad idea. What I want to say, though, is that incorporation is not nearly as scary or as expensive as you may think. And incorporation is essential if you want to be a growth company. If you want to grow, meaning you want to bring on a lot of employees, you might bring in some investment, you might, want to hire, give people stock options and stick around. The only mechanism, the only vehicle for that is to incorporate. So this is why I asked you what you want to be when you grow up. What you see today may not be where you see yourself in 5 years or 10 years. So set yourself up for success early is the point of this. I want to touch briefly on social enterprise, not-for-profit, and charities, because I get a lot of questions about this, and there's a lot of misunderstanding out there as to what these different types of businesses mean. So I would say a social enterprise has many meanings to many people. But a social enterprise could be either a sole proprietorship or a partnership or an incorporation, I would argue. But generally, I like to think about them as corporations. And what I think about is that their social cause is what separates them from a different type of business. But they're for profit for the most part. It's just the profit goes, or a percentage of the profit goes to a social good. And that's the separation. That's the difference. They are incorporated companies, for-profit incorporated companies. They grow, they have shares, they have shareholders, they have directors. They run as a normal business. They just determine that they have a vision to do social good. And there's so many misperceptions about that I just want to make sure that maybe someone would disagree with that, and that's okay too. But I don't like people thinking that social enterprises mean that your company can't make money or that you as the owner of the company can't make money. Because in my experience, if you go in with a plan that you're going to grow and make money, then you have more money, don't you, for your social cause. right? And you still have to be sustainable. You still have to find a proper business model in order to sustain your company. And that's how you're going to be the most effective social enterprise. And I compare that with a not-for-profit, which is actually a type of business that you do not own shares. You cannot make profit. It's a different type of incorporation for a company without shares. And that is truly a company that cannot raise money from investment or selling shares, selling equity. And these are largely companies that look for donations or government support. We all know that's becoming more difficult to get as time goes by. And I would argue that even a not-for-profit needs a sustainable business model. So if you formally set yourself up that way, that's fine if that's what you want to do, but know why you're doing it. See if this is part of what you want to be when you grow up. A charity, just for the sake of explaining, is a completely different situation. It's a status, it's not a type of company. You go look for charitable status so you can issue tax receipts. That's a process. It's a long process. It's a complicated process. You need a not-for-profit to do that. So that's a whole different world. And people often intermix these terms, and I just want to kind of set the record. I've had people incorporate companies and they don't even know which type they've incorporated. They've done it themselves. I had a client last week told me he created his own not-for-profit, and when I looked it up, he was not a not-for-profit. He was a for-profit enterprise. But I tell you what I see more of than I expected. I see a lot of companies come to see me and they tell me they're incorporated. And when I look them up, they registered as a partnership and didn't know the difference between a partnership and a corporation. So I hope I have at least answered that question for you. And again, I'm watching the chat. I don't see anyone in the chat. Don't have let me get my participant list up. So if anyone has a question, see that going too. Please feel free to talk to me. I could be more helpful if I know what your issues are. I'm going to keep going until I see a hand or have a question come my way. The next question I want you to think about is, who do you want to be in business with? What do you think of when you think of your business? I'm sorry, I'm sitting down and I'm probably moving my camera all over the place as I move my legs. Who do you want to be in business with? And this will go back to the business structure. Do you just want to be in business with yourself and do you just want to do your own little thing, which is perfectly fine? Do you actually want a partner in terms of the legal term of a partnership? Partnership is another word that gets used very loosely in the business world. But when you're a lawyer, someone says partnership, our mind goes to the Partnership Act and partnership agreements. If you want a partnership that works for you, or for some reason the law requires you to be a partnership, or for some reason you can't incorporate now, get an agreement in place. Make sure you spell out the terms and conditions of your partnership and how it's going to survive if someone leaves, or if there's any different way you want to split profits. Make sure you get all that in writing. It just makes things a lot easier. If you're going to be in business as an incorporated entity, you can do that alone, by yourself. You can be the 100% shareholder. But if you have a co-owner, then I strongly recommend you have a shareholders agreement. And this does not have to be complicated, although I will suggest you use a lawyer, because it needs to set out the rights of each of the shareholders. And I always get feedback, but we trust each other. And I think that's wonderful, and you should. And the partnership or the shareholders agreement should not in any way cause you not to trust each other. It should be a document that you draft when you like each other, you put in a drawer, and hope you never have to holler to the drawer. Because there are often times when you won't like each other, and someone needs to leave or wants to sell their shares, or someone becomes disabled, or someone dies, or someone gets divorced and their partner ends up with half the shares and you don't like the partner and now you have a shareholder that you don't want to be in business with, and on and on and on. There are so many things that can happen without a shareholders agreement. So if you are a co-business owner with somebody and you both hold shares, please take the time to do a shareholders agreement. You will be happy that you did. I can talk in detail about shareholders agreements. You can ask me questions about shareholders agreements. I can explain a clause that you might not understand. If you've seen a shareholders agreement, you just ask away, but I'm going to keep it general unless you ask me a specific question. The next kind of advice or issue: who are going to be the directors of your company? And now I'm assuming an incorporated company, because partnerships and sole proprietorships do not have directors. First of all, what is a director and how is it different from a shareholder? Well, they are completely different legal hats that you're wearing. You might be the same person. How do you register a partnership? A partnership can be registered, I'm thinking Newfoundland now because I practice in Nova Scotia these days. Very easy to do. I believe it's just a registration form that you fill out with the registry of companies. There are no formalities other than that. It's really just you don't file an agreement. You don't have to do anything formal to register your partnership. I can't remember exactly how I do it in Newfoundland. I got to write that down to find out for you, Richard. Just hang on, I'm going to make a note. In Nova Scotia, you go to the registry and you register by giving your name. That's all is to it. Something tells me Newfoundland's even simpler than that. Hang on, I'm going to find a pen. Okay. I'm just going to verify that. If it changes from what I said, I'll let you know. But it's really a matter of going on the corporate registration website. And I think filling out an online form. I think they want to make sure your name is clear, and I think that's all is to it. But there will be nothing more than the Partnership Act governing what you do. And that's really important to understand, that you really want to put something in place that deals with it. But you can override the act with your partnership agreement. Okay, the directors, let's talk about directors. Directors and shareholders, you could be the exact same person. And most often in small businesses, difference between an LLP and a regular partnership. People really want to know that. So I don't usually get into the difference between limited partnerships because most people don't really go that deep, but I certainly can. So you can have a limited liability. There are 3 different types of partnerships. There's the basic partnership, which we just talked about. And there's the limited liability partnership. And in a limited liability partnership, and there's also a, what's the other one called? Can't remember the name of it. Anyway, it doesn't matter. A limited liability partnership is just another version of the partnership where a partner can limit their liability to just the amount they put into the partnership. But that limited liability partner cannot be part of the day-to-day affairs, cannot have any decision-making power, cannot do anything special with the company. So those are very specific forms of, I don't know if you're going in here with me as I do this, just going into the registry. This is what you call on the fly. So take the registration form, give the name of the partner, name and residence of the partner, letter of consent, who's authorized, the fee. Yeah, so it really is just a registration form on the government site. Let's go in here and see. This is for a limited liability partnership. Not much to it, is it? That's not your general partnership, though. Okay. Get out of that. Okay, here we go. No, you don't see anything on the screen. Oh, I couldn't tell. Sorry, I just went into the link that Richard showed me. And there is a form there to fill out for a partnership. So it is, as I said, you just go in and fill out a form. Okay, so if you're interested in partnerships, you should talk to me because that is not a form of it is not a form that I would recommend. So if we're interested in that, can we discuss it? Can someone tell me why you're interested in partnerships so I can talk you out of it? Anybody want to talk to me? Going into this other screen now to show you. Anyone want to ask me questions about partnerships? Not a form that I am recommending to you. It's full of complications. So I'm now into, you can see this now, right? I'm into the registry of companies. This is where you would go if you're coming in to register a company. Richard, I got to stop following your links. You're bringing me down two wrong paths. This is where you would go in to register a company. I thought we were going to go look at the partnership. Anyway, I'm moving on from that. You should be careful that you know what you're doing before you enter into any kind of partnership. See a lawyer, get a partnership agreement drafted up, and don't be afraid to think about incorporating. Incorporation takes, I think it's $300 in Newfoundland. I always tell companies that if you file your own, I think it's fine to incorporate your own company, but do so only if you're doing it by yourself. I think if there's more than one person incorporating a company, you really should get a lawyer because you have to be careful about the other party and what you each need to get out of it. You want your share terms to make sense. You want it all to kind of coincide with your shareholders agreement properly. So you really should have someone do it for you. Let's talk about directors. This is important. A lot of people do not know that as directors, they take on personal liability as a director. And that means that under certain circumstances, you can be held responsible for certain things that come up, and I'll just explain some of them, what they are. So as a director, you're responsible for the payment of all taxes for your company. And under the Income Tax Act, you can be held liable as a director for not paying your income tax. HST is the same. Revenue Canada can go after directors if you fail to pay your HST. So please make sure that you understand that. Workers' comp can attract director's liability. Failure to pay, I think, 6 months of employee wages can attract director's liability. And there are some more kind of issues like environmental concerns can attract some director's liability. You're still talking about partnership. I'm going to go back and learn all about partnership before we forget. The other thing to note about directors is you're responsible for the day-to-day affairs of the company. This is not a shareholder decision. It gets delegated to directors. As shareholders, when you have that hat on, you actually have very little say. You get to appoint the directors. You get to approve the income statements every year, and you get to approve any major changes in the company. Otherwise, it's left to the directors. So we want to make sure that you have a good board of directors with you. So when I ask you, who do you want to be in business with? who's on your board of directors. And make sure those people, if you bring in outsiders and you want them to help and they're willing to do so, make sure they have the best interests of the company, because that's the responsibility of directors. A lot of times the shareholders become the directors. If there's 2 shareholders and you become 2 directors, we often have issues with the directors disagreeing. And usually in the directors world, it's majority rules. So if you have 2 people and there's 50-50, sometimes it's hard because everything has to be done on consensus. So think about that. Think about that for your company. And if you'd like to have kind of a third party in there who can kind of break a tie, or someone that you trust to be part of your company, think about that. I do not recommend you take on directors lightly, because directors have significant power in a company. Okay, I'm going to keep on going. Next question for you is, who do you need to help you get there? So we're still thinking about your long-term vision. So think about your company and where do you want to take it? Who's gonna help you along the way? Do you have advisors? Do you have a board of advisors? A lot of companies don't have a formal board of directors. They have advisors, and they invite people who are kind of knowledgeable in their industry to kind of advise them. Be careful that you understand that they are just advisors. They cannot tell you what to do. They do not control your company. They're there mainly in an advisory role. And I would say the same thing about mentors. If you do share information with your advisors and your mentors, confidential information about your company that you really don't want anyone else to know about, you could ask them to sign a confidentiality agreement just to make sure that they're not going to disclose. If they're helping you design anything of value, like a prototype, or your advisor's an engineer or a chemist who's giving you advice on a recipe or a formula, you have to be really careful about who you ask to help you with these things, because they could claim to own part rights to ownership of the intellectual property that might arise from the formula or from the prototype. So be very careful how you treat these advisors and mentors from a legal perspective. Of course, you mostly just wanted them there for advice, and that's wonderful. And we all need good mentors. But keep in mind, depending on what your product is or what your service is, what might be confidential and you don't want them to use or have rights to. You're most likely going to need employees as you make your way through your journey to your vision for your company. Think about your employees for a second from a legal perspective. I think, first of all, about risk of having employees who are not trained, having employees who you do not do proper reference checks and you have no idea what you're taking on. And I say both of these things because of a legal principle called vicarious liability. And if your employee does something that causes a problem, the company can be the company can be liable. So you're vicariously liable for what your employees do while they are at work or while they are working on your behalf. So an example, what are some of the cases I've seen? A case, it might be extreme, but it actually happened. If you're a security guard company, you hire an employee. The employee gets, in this particular case, the employee was asked to go guard a warehouse, and instead the employee decided to burn the warehouse down. They looked to see if the company had done proper reference checking, and if they didn't, and it was found that the person had a prior history of starting fires, the company could have been liable. In this case, they actually found that the company was liable because he was in the course of doing his duty that he decided to burn the warehouse down. A much less kind of extreme example, a someone takes the company car home for the weekend because they're going back and forth to work and they have a car accident and somebody's hurt, the company can be responsible for that, not the employee. So be careful. And all that leads to having proper documentation, having an employee handbook with your codes of conduct, your rules, whatever you want to call it, what the employee can and cannot do, what restrictions you're putting on their cell phone use, their computer use. What else do I see in them? Their use of company vehicles. All the things that you want to make sure that you put in place so that you can start growing your business in a kind of a structured and create that culture of policies. You don't have to over policy it. You don't need starting out a 50-page handbook. You just need to start setting out some basic guidelines that your employees need to follow. And then all that should lead into an employment contract. Newfoundland in particular is famous for not putting employment contracts in place. And thank you very much, because as lawyers, we make a lot of money when you don't do that, because we have to go clean up the mess. But get your employment contracts in place, most importantly, for clarity. So everybody knows what's going on, what their vacation's going to be, what their benefits are, if any, what their hours of work are. Just put it in writing. Most importantly, a deal with termination. It's probably one of the most important reasons to have an employment contract. Is you can set out in writing what the terms are for terminating an employee, what their severance will be, what cause is, what you can do in lieu of payment. But if you don't have that, you have to deal with the common law. And the common law gives the employees far greater rights than you have to by law if you have an employment contract with them. So take the time, get a lawyer to develop a good employment contract for you, and then you can use it for all your employees. It's worth the investment. The other group that might help you get where you're going is what we call independent contractors. And I see this a lot more than I see employees, because the companies that I work with are very early stage. We incorporate most of them ourselves, and they can't afford employees. And some of you on the call are probably in the same kind of boat. So you will rely on an independent contractor, somebody who you can pay a certain amount of money to do a certain job for you, and then they kind of go away. And they're different from employees because they're not, they don't have rights to any health benefits. You don't have to collect CPP and EI for them. You just pay them a lump sum and they pay their own taxes. You have to be really careful with these types of relationships, because you do not want the law or Revenue Canada determining that they're not actually independent contractors. They're really employees. Because an independent contractor is a cheaper way to have someone working for you. It's like I said, you don't pay taxes for them. You don't take responsibility for them. They're not on your salary. They're not on your payroll. They're not in your health benefits. But if you treat them like employees in all other ways, then the law can deem them to be employees. And then you owe money to Revenue Canada. So if you're going to have independent contractors, have it in writing. You'll notice the theme going through all this, have everything in writing, and make sure you allow the independent contractor independence, which is really what sets them apart from employees. Meaning give them a task to do, let them go off and do it, pay them when the task is done, don't put too many parameters around how they do it and the tools they use to do it. But independent contractors are a big part of helping you get where you're going. A common independent contractor for many of you might be hiring that contractor to do your website for you, for example, or to help you make your logo, help you design your brand. These are independent contractors. The other really good reason to have something in writing with your independent contractors is that, let's say this party designs your website, or takes some pictures and posts on your website, or creates your brand for you. unless you have in writing with them that your company is going to own all the intellectual property rights, this third-party contractor will own the IP. And even if you pay for it, what you own is the right to use, not the right to own it, not the right to have access to the source code or the underlying code or the actual drawings. So if you wanted to change the color, you have to go back to the copyright holder of your logo and ask for permission. These are things you don't want to have to fool around with as a small business. So you want to make sure you get it in writing that you're going to own all the IP right from the beginning. Any questions on that? That's often a surprising piece of information that people need time to get their heads around. They think, if I paid for it, I own it. Well, sadly, the law does not see it that way. And I can think of many examples where people have gotten caught with this. Websites are a big example. Logos, designing your logos, another big example. In my world, getting software developers to develop code for you, and then you try to get access to the source code, and you can't get it because you don't really own the source code. So these are things that happen all the time. Okay, the next thing, who are your customers? And this could be, I have no idea what your businesses are. Well, I have some idea, but think about who your customers are going to be now and who your customers are going to be in the future. What kinds of agreements do you have in place for them? What kind of process do you have for them buying your service or your product? Do you invoice? Do you have purchase orders? Do you use the Square? Like how do you make your arrangements with your customers? Is it a website? Do they go on and click they accept? Do you have end user agreements? If you're using a website, do you have terms and conditions of use on your website? Even in your invoices, do you set out the basic parameters? Or quotes? Do you say this is just a quote? It's only valid for 90 days. It's all whatever is extra or any changes we have to agree upon. And even in your invoice, you could have the back page full of terms and conditions, which you'll see oftentimes in more sophisticated companies, but there's no reason why you can't do it. Do you understand what you're selling, but more importantly, what your obligations are that go along with that sale? Do you have warranties? Do you have to do repairs? Have you met standards? Are you putting warnings on your products? If you're selling coffee, is it going to be too hot? I mean, what are the things that you have to think about when you're dealing with a customer? And what legal arrangements should you have with that customer to help prevent you from facing unnecessary risk? So I will again suggest that you have proper documentation and agreements in place. And we can talk about all the different types of agreements you might need. This might be a good time to mention the risk of internet lawyers. There's quite a few of you out there. Again, in my practice at the clinic, we see clients come in every day that have drafted their own agreements, found a precedent online because there are many, many, many. And NDAs is really one we see a lot, non-disclosure agreements, where people are signing their own. The problem often is they don't understand what they've hauled off the internet and what they're signing. And sometimes that's even more scary than not signing anything at all. So please be careful. It's amazing to me how many times I see a document that the party doesn't even understand. And it doesn't even reflect the deal. So be very careful to know what it is you're selling, what you want to make sure you're responsible for, and what you want to make sure you're not responsible for. So please take time. I know it can be expensive to have a lawyer, but sometimes it's better to have the prevention than to worry about the fallout at the end of it. Okay, anything about that? Any kind of customer agreements that you can think of? Any kind of legal risks that you want to talk about? God, Ken, you didn't tell me they were going to be so boring. Talk to me. This is all interesting stuff. Okay, let's talk about this part. Let's talk about risks. I just started making a list of all the risks that I can think of for companies that were on the list that Mary gave me. What are your risks? Product liability. Are you selling homemade wine, homemade beer? You know, the old legal case, the snail and the ginger beer, that type of thing. Are you supposed to be providing a service? Is there a delivery? Are there deadlines? Are you supposed to pick up a vehicle at a certain time? A lot of you are in restaurants. Some of your risks are food poisoning, inadvertently, of course. Contamination, if you're trying to run a gluten-free place, what happens if someone gets sick? Slip and falls can happen on any of your premises. There are automobile accidents. And a lot of this comes down to the legal cause of action, negligence. So I just thought we might spend a couple minutes thinking about that, and then thinking about other steps you could be taking to mitigate. So what is negligence? You know, it's probably the number one legal risk that your companies are facing. And negligence is an unintentional tort, which means you didn't try to hurt somebody, but because of either your carelessness or your lack of attention, somebody was harmed. So in terms of a slip and fall, if you just washed your floors, but you forgot to put the sign up, wet floor, and somebody slipped and fell, your business could likely be sued for negligence if the person was hurt. Contamination, you know, if you've accidentally picked up a carton of eggs that was recalled, or you have one in your fridge and you didn't check the recall, and people got sick after you became aware that they had a risk of causing injury, then you could face negligence. Product liability, if you are selling a craft or a child's toy and the eye comes off and a child chokes, and now I'm thinking about morbid things, but these are all things that I'm trying to get you thinking about in your mind about what could happen on your premises and with your product or service. So negligence requires three steps. First of all, do you owe a duty of care? Most cases, well, if it's your customer, you definitely owe a duty of care. If you're driving and there are other drivers on the road, you owe them a duty of care. If someone's in your restaurant eating, you definitely owe them a duty of care. If you're selling your product to the intended target, you owe a duty of care. It's the standard that's important to think about. And the standard is being reasonable. And the law will look at, did you act reasonably in the circumstances? So if you could have easily put the sign up that your premises were, your floor was wet, then that would be reasonable for you to do. If you could have checked the recall and thrown out that carton of eggs, that would have been reasonable for you to do. So you have an obligation to act reasonably in the circumstances. If your product was a new method of killing COVID germs and you failed to say that it was toxic and somebody thought it was a smart idea to ingest it, I'm making this up as I go, then you would probably be considered negligent. So putting your warning signs on things for product liability and testing and doing inspections, all the things that would be reasonable in your line of work, in your industry, in your type of company, you have to start thinking about whether you're doing that. So let's think about the steps you take to mitigate. Training is very important. Are you training your staff properly? Are you training yourselves properly? Are you taking all the steps to become as familiar as you need to be with using your machinery or operating whatever you have in your kitchen? Are you training everybody? That's a good way to mitigate your risk. Are you training people to wash the floors properly? I know this might sound trite, but it's very important. Your snow clearing. Do you have a schedule for snow clearing? Is somebody looking at it every hour because it's Newfoundland? People that you hire to do your walkways and your driveways, are they putting salt down when it's icy? Are they on a schedule? Do you have it checked regularly? I've seen cases where that didn't happen and should have. Another way to mitigate your risk are through those contracts that we just talked about with your customers. In some circumstances, you should get your customer to sign an agreement. Now, you're not going to get someone walking into a restaurant, can you sign this before you sit down? I'm not liable if I poison you. That's probably not going to work, but there are a lot of other circumstances where it may be sensible to have contracts where you can limit your liability in the contract. Say, I'm not liable if this happens, type of thing. I believe someone on the call or on the list anyway was a photographer. Imagine if you're shooting a wedding and then you accidentally lose all the data and all the pictures. You might really want to have something in your contract that says, sorry, but I'm not going to be liable if something happens to all the pictures I just took of you. For example, just coming off the top of my head. So you can limit your liability. You can mitigate your risk of loss through contracts, through putting in your limitation liability clauses properly. And finally, insurance. Think about your risk, think about your exposure, talk to your insurance company about your business, and they'll probably ask you more questions than you can answer anyway. But make sure you have the right type of insurance for the right type of business that you have. I do not recommend that you decide not to tell your insurance company all the things that you do or you could be doing. You want to make sure you're covered for that liability. Any questions on any of that? Okay. Let's talk a bit about how you're going to reach your customers. How are you going to talk to your customers? What's your marketing strategy going to be like? What's your brand? How are you going to find your customers? Is it going to be on Facebook? Are you going to take out ads? Do you have your own website? What are some of the legal issues that can arise in these situations? Let's talk first about your brand. Let's say you have a brand and you have a nice logo and you might even have a little tagline. These are what we call in the law trademarks. If you use a slogan, a name, a graphic, today it can be smells, it could be sounds, it could be senses. If you use anything that you associate with selling your goods and services, that's your trademark. So in the world of trademarks, you have to be careful of a couple of things. First of all, you want to make sure that your trademark is unique. And you want to make sure that your trademark is not infringing on the trademark of anybody else. If you have a name that you use consistently in association with your advertising, and that could be your business name, but it could also not be your business name. Your business name does not have I'm looking at the chat here, sorry. Okay, thank you. If you have a name and you're concerned that you want to make sure it's unique, that someone else doesn't have the same name, you could, all right, I'm sorry, I got confused by looking at the chat. I was saying that your business name, that your registered business name does not have to be your trademark. It does not have to be the same name you use to associate with your wares and services. So I always use the example that Subway, which is one of the most common trademarks in North America, the company name for Subway is Doctors and Associates Inc. or something like that. So your business name could be a numbered company, could be anything. It does not have to be the same as your trademark, but it can. So make sure you distinguish the two for various reasons. Okay, so brands are usually what we call our products, and that could very well be the same as our business name. But the brand has to be unique. You do not want to be using the same brand as someone else. And there are two ways to look at this. One is, why would you want to brand your company the same as someone else's? So your idea is to be unique in the market and to create brand equity with your own company, so that when someone sees a logo or hears a name or hears a slogan, they instantly recognize it's your company. That's the golden place you want to be. So Nike is an obvious example. I could say, just do it. And you know I'm talking about Nike just by those 3 words. I can show you a swoosh and you instantly know it's Nike. Those are very powerful brands because they start to speak for themselves. And that means you have brand recognition and you actually have built up a lot of equity and goodwill in your brand, which is where you want to go. So imagine if you're spending a lot of time doing that and then you find out that you've infringed someone else's brand and all of a sudden you can't use it. So you really have just wasted quite a bit of time and put a lot of effort into something that you have to stop using. I always use this example because it was in the Evening Telegram and kind of makes it more real. I do not know this person. I only know what I read in the newspaper. This person was not my client. So I just want to say that this is just public information. And it was probably several years ago, but it's still a great example. A person started, a woman in St. John's started a basketball, kind of a private basketball camp after school where she was training some kind of the higher level athletes or people who were very interested in increasing their skill level. And I believe she called her basketball camp Shooting Stars. I believe that's what it was called. And I believe, if I recall the article in the Telegram, she had that brand for 6 years. And she had a lot of brand equity. She was getting very well known. A lot of kids were going to her camp. And, you know, she had her logo and all her marketing material all said Shooting Stars. And one day she got a cease and desist letter from a company in BC saying, stop using our trademark. And she was devastated. And I know she was devastated because she went to the Telegram and told her story about, and I probably have changed this in my mind because it was several years ago, but as I recall, it was, how dare that big bad company in BC tell me I can't use Shooting Stars. And, you know, and then people were writing in and commenting on how this big bad company should never do this to this little company in Newfoundland. But the reality of it is, that's exactly what this company in BC should have done. And it wasn't a big bad company. It was a company, but it wasn't big or bad. It was just a company that also had put a lot of work into the brand Shooting Stars and had actually registered a trademark, Shooting Stars, and had rights to Shooting Stars all across Canada. Because once you file a trademark, you own rights. It's jurisdictional, so you own the rights in the country in which you register your trademark. Having said that, if you had, if the person had been given a little bit of advice and had a little bit of knowledge in how to search the trademark database before she opened her business, she could have avoided all this and she could have picked another name. Because just for curiosity, I went into when I saw this in the newspaper, I went into the trademark database and searched. They're free to search, and put in Shooting Stars. And I found this company in BC who had a website, who had a trademark, Shooting Stars, and their wares and services were sports camps for kids. You cannot find a better direct match to what she was trying to do. So it's important to understand that. The trick is, the test is it confusing to the market? So there are often trademarks of the same. Garrison is a name I always think of because I once registered a trademark for Garrison guitar. And there was Garrison batteries out there at the same time. That's not confusing to the market. batteries and guitars can coexist in the marketplace with the same name. And there are several, right? You can probably think of several. If it's in the same industry, the same market, the same customer base, that could cause confusion. And it looks, sounds, spells the same, then you're going to have a problem with the trademark office, with the trademark owner. So these people in BC did exactly what they should do. They have to protect their trademark to keep it unique. Because we can all think, if we took a minute, of examples where someone had a trademark, and because they weren't vigilant and they didn't protect it, that trademark became more of a ubiquitous word that they no longer could claim they have proprietary rights to.
Jacqui,
So,
we have a few questions in the chat.
Sorry?
We have a few questions in the chat.
Oh, I'm sorry.
No problem.
Questions in the chat. So answer my question before I go back to the chat.
We have 3 questions.
Think of a trademark that no longer has protection. No? I'm going to put something in the chat.
No. So I have one. I can read it.
Okay.
I have one from Vicky. Our company name is Coldwater Foods and Cafe. If we want to use Coldwater as our brand, should we trademark it? That's the first question here.
Oh, no, I can see the chat. Sorry.
Okay, you got it.
To my question. Okay, forget it. So I'll just shoot that out and then I'll go back to the chat. So I'm thinking brands like Kleenex. We don't call a tissue anymore. We call it a Kleenex. The word Kleenex is used so much, it really has no value as a brand. Now, can you think of another one? Shout it out to me. Skidoo is another one. A Skidoo is actually a brand name, but we, especially in Newfoundland, everything is a Skidoo. So the word Skidoo doesn't have as much value as a brand anymore. All right, I'm going back to the chat. Our company name is Coldwater Foods and Cafe. If we want to use Coldwater as our brand, should we trademark it? Yes. Okay, let's talk about should you trademark. So let's let me see if the next question is the same. As an event planner that rents venues, can you talk about liability insurance? Okay, sure. Okay, let's finish our trademark discussion. If you want the best protection available to your brand, you should trademark it. But you also have to be mindful of your resources and whether or not you can afford a trademark. So before I get into how much it costs and the process for doing it, there are common law rights to a trademark. So if you have Coldwater, for example, and you know that there are no other Coldwaters, first of all, I would do a trademark search to see if Coldwater is already registered in Canada. That's the very first thing I would do. And after you're okay with that, I would make sure that you're not aware of people using it without registration. So I would do Coldwater searches on Google and whatever, Facebook and whatever other platforms you can. Try to make sure you have it as unique as you possibly can. And then I would tell you to consider using it, if you're not going to trademark, consider using it as your brand and make it very clear it's your brand and try to create as much awareness and marketing and brand equity in it as you can. Because in common law, we also have rights to trademarks, meaning if you establish Coldwater as your brand, you're going to be able to prevent others from your geographic area from having Coldwater. So that's the difference between the common law right and the registered trademark. The registered trademark is good all across Canada, but if you have a common law right, it's only good in the geographic area that you're actually using the trademark. Okay? So you'll notice if you look at trademarks, and now you will because we're having this conversation, you see them with a TM in the corner, and then you see others with an R in the circle. So a trademark with a TM in the next to it is an unregistered trademark. It's still a trademark under common law, and you can still build brand equity. When you register it, that's when you put the R in the circle, and that distinguishes it as a trademark that has protection all across Canada. So to answer your question, if you don't want a trademark, you still have to make sure it's your brand and you're not infringing anyone else's. And then when you use cold water, if you have a font, if you have a color, if you have a logo, I would advise you to use it consistently that way every single time you use it, so you create brand awareness. If you keep changing the color, or you keep changing the font, or you keep changing what taglines, that creates confusion. You're not creating any kind of awareness. I would also recommend you have it on your website or whatever your marketing is, and I would use the TM next to it, because it shows the world this is your trademark, and to stay away from it. So if you decide to trademark it, what are the things you consider? First of all, if you think you're only going to stay in your small geographic area and you don't need protection across Canada, then you may decide it's not worth the money. Again, assuming you've made sure there are no third parties that you're infringing. You also want to decide if you can afford it. So the general cost to file a trademark, if you use a trademark agent in Canada, is $1,200. You can do it yourself. Canadian Intellectual Property Office has made their website much more user-friendly for people to file their own trademarks. And there's lots of online self-help things for you to file your own trademark. And in fact, if you went to the website of my clinic, the students have written a really nice step-by-step do-it-yourself how to file your own trademark. You can go there and see that. And that is, just put the name of the website right here. Okay. So, and if you're interested in having a trademark agent to do it for you, then I can certainly help find you one if that's of any help to you. When you file your own, you don't pay the trademark agent fees, you'll just pay the filing fees. I don't exactly remember what they are, but they're like $200 or $300. So just so you know, Canada, from what I've heard, is 2.5 to 3 years behind in actually adjudicating and getting their trademarks reviewed. That's how backed up they are. Everyone during COVID wanted to start a business and file a trademark. It's a very good time to be starting a business. Okay, so that's that question. I hope I answered it to the best of my ability. If you have any more questions, let me know.
I think, sorry. There were 2 more, Jacqui.
Yeah, I'm looking at this one. As an event planner that rents venues, can you talk about liability insurance that I'm responsible for? What is the venue I rented from responsible for? So the best way I can answer that question is it depends on what you've agreed to them, who's responsible for what. So this would be a perfect example of how I would suggest to you as an event planner who rents venues that I would have a checklist, or I would have a draft of an agreement done up the way you want responsibility to lie. And I would suspect, and I could be wrong, that every venue you rent may have a different way of tackling it. Some may have a certain type of insurance. Some may put all the risk back on you. So I don't believe there's a standard answer to your question. I think it's a question you should ask with every venue that you rent. That would be my advice to you. As for your insurance, I wouldn't, I'm sure you don't want to, I suspect you don't go get new insurance every time you do a different venue. So I think you would want to tell your insurance company, this is what I do, these are the venues I rent, and let your insurance company say, okay, well, we're going to cover you for this, this, and this, but not. So let's say, for example, you rent a venue, you need to go in there and use their stove or oven, and you assume that the venue has insurance for anything that happens, like the oven blows up or the microwave blows up or something happens. I would assume that too, but I don't know if you can assume. I don't know if they push the risk off on whoever kind of is the tenant, whoever's renting at the time. So I know you would want commercial liability insurance. I know you would want content insurance if you're bringing in anything expensive, like if you have desks or chairs and tables and fancy silverware and that type of thing. You would want all that insured. As for what the kind of landlord or the venue would do, I would think that depends on each one. I wouldn't assume anything. I would make sure you get it in writing what they're responsible for. I know that's vague, but lawyers were famous for vague. You make a living off of it depends, but I don't think there's a standard answer. All right. So I don't see any more questions. Mary, am I missing one?
No, I think you're good.
Okay. Oh, we're going to get one coming here now.
There is one from Jennifer.
Seeing it here now. We have a local community garden utilizing the property we are in the process of buying. We would love them to stay. But would liability be on us, or do we need agreement so liability we're following them? Oh, I see. So you're trying to buy property, but there's already a garden, community garden, and you want them to stay there. Okay. We would love them to stay, but would liability be on us, or do we need an agreement so liability would fall on them? So if you think back to what I just said about negligence, which is probably what we're really talking about here. If you buy the property, you become owners of the property. If you allow the community garden people to access the property, you are the kind of owner, you're in control of the property. And that means, as the owner of the property, you would have an obligation to make sure that property, and you know there are people coming onto your property because there's a community garden there and you want them to be there. You're kind of inviting them onto your property, and that means you would be responsible for making sure the property is well taken care of. Like, you know, if there's any, I'm just thinking off the top of my head because I don't know the actual property, but if there's a fence and or there's a gate and someone gets caught because there's a nail sticking out, I don't know, I'm making it up as I go. But I can't think of a winter issue because I'm assuming it's a summer issue if it's community garden. Or if you left the gate open and a goat got in and ate all the vegetables. I don't know. I mean, I would think because you now own it, if you don't put an agreement in place with them, I mean, I don't think you're going to be liable for their plants dying and that type of thing. But if any damage comes to them because you as the occupier of the property did not take steps to prevent it, I would say you could possibly be liable. How do you prevent that? An agreement in place would be really good if you could get them to do that. If you can't get them to do that, I would put signs up saying, you use this at your own risk, the owner is not responsible, be careful, enter these, this is private property, but we're letting you use it as long as you use it at your own risk. I would do something to make everybody aware that you're not upkeeping that property and that they're using it at their own discretion and risk. Or I would put an agreement in place with them, which would even be better. Because in the law, we have occupier's liability, which is negligence that basically creates a duty on the person who occupies or controls the land to make sure everybody else is safe. There's lots of cases on even your own property. And you have a pool in the back garden, for example. And that pool in your back garden, you just happen to know that there are kids in the neighborhood that would love to get into your pool. So you have to be reasonable. And that often means you put up a high fence. You have to put a lock on the gate going into your back garden pool. So it's your property, even though it's your private property, you know people can access it and you have to be careful for them. So I don't see this as much different. Any other questions? See how much more interesting it is when you ask me questions and we can talk about things? All right. The brand, I think I managed to perfectly talk that to death. So think about that brand and think about your website and how you use the brand, and think about Facebook and how you use the brand, and Instagram, how you use your brand. Be very consistent. Brands have the most value when they are easy to recognize, easy to spell, easy to say. That's what creates that, and actually have very little to do with what you're selling. You don't want to be too descriptive, because then that's hard to separate you from the next person selling the same thing. It's those brands that you create something, some awareness that's very unique, but somewhat different from what you're selling. And I always think of Apple, because Apple is a fruit. And now when I say Apple, you don't think of fruit, you think of computers. That's a brilliant brand. Simple, easy to spell, easy to say, easy to recognize, but it has nothing to do with the product. Those are very powerful. Those are very powerful brands. Okay, so I'm still thinking about a website and the legal liabilities, the liability you might attract on your website. And I often see companies that have pictures on their website, and these are pictures they have borrowed from another website or from a database where they don't have rights to the photographs or the images. So be careful with that. There are so many websites where you can purchase images for your site that are very inexpensive. Make sure you check the licensing rights from any pictures that you're planning on using, and make sure you can use them for commercial purposes. The big part of your website and your Facebook page, maybe not Facebook so much, is looking sophisticated. Not looking like you're rinky-dink, looking like you're like a real company. It's the great equalizer. No one can tell from a website if you're large, small, new, old, big, it doesn't matter. That website, if done properly and you look sophisticated, says a lot about your company, whether you know it or not. So use your TM, make sure you give credit where credit is due, have your terms and conditions of use, have your privacy policy up there if you're collecting any type of personal information, even if it's their name, their phone number for a reservation. Just let them know that you're not sharing their information, that you're not using it for any third-party purposes. It just makes your site look really good. If people are paying for things on your website, so you have e-commerce, you really need a privacy policy. People need to know what you're doing with their credit card information, where you're storing it, how long you're storing it for, what you do with it. Do you have proper security protocols in place? How long you will store it for. So I'm just going through all the privacy rules in my head. If you're collecting data about your customers, what data are you collecting? What are you collecting it for? How long are you storing it for? Are you keeping it safe? Those are very important concerns. And if you're trying to create trust with your customers through an online portal or e-commerce, people are looking at your privacy policies before they buy things, because they want to know that they haven't just given their money to a company that has no respect for their privacy. I look at privacy policies before I buy online, unless it's a very sophisticated company. Be careful spamming. We have anti-spam laws in Canada. Spamming means sending out to people who don't want to hear from you in a big email list, which tells them about your latest specials and that type of thing. Email lists are wonderful, but get permission to add people to it. So a couple ways to do that. You, when you collect information on your website, you have them tick a box to opt in and say, I want to be added to the list. Whenever you send out new product ideas or new specials or newsletters, please include me. Or if you happen to be collecting business cards at an event, make sure you say on the sign, put your business card here. If you do, you're giving us consent to contact you for any, if we have any, anything that might be of interest to you. Or this is not great, but it's better than nothing. You have a list, you send it out saying, I'm contacting you because you once gave me your email address. If you click unsubscribe below, I will never contact you again. Not great, but not as bad as continually emailing someone who does not want to be contacted. So always have the unsubscribe option if you're going to start sending out mass emails to people. Your marketing material, I would say the same as I would watch the photographs you're using. Be careful of what you're saying about your product. Don't misrepresent it. Don't say it does something it doesn't. Don't, if you have warranties, state what they are. Don't oversell it. Don't make claims you can't back up. Don't dish your competition. Use your brand wisely, that type of thing. Use your brand consistently all the time. Any questions? I mean, don't defame others on your Facebook site. You know, that stuff goes without saying, but you know, just be clean, be generous, be thankful. Nothing coming out of that. Okay, keep going. I don't remember what I have after this. Okay, so this is probably something you're thinking about, or I hope it is, especially if you're in the food industry. Are you regulated? I mean, to some extent, you know, even though we live in a free market world, we're all regulated. We're all regulated by Revenue Canada. We all have tax filings and HST filings and that type of thing. Just a note on HST, because a lot of people don't know this. If you collect $30,000 or more in revenue in a fiscal year, you must be an HST collector. You have to be an HST recipient. And you have to pay that HST to Revenue Canada. So if you didn't know that, there's just a little point for you. And we're all bound by labor standards, which is the floor, the minimum way we have to treat employees. Every province has that legislation. We're all bound by workers' compensation. Whether or not you pay workers' compensation premiums depends on your type of business, how many employees you have, that type of thing. We all have occupational health and safety requirements. Again, depends on the number of employees, the type of business you're in. So make sure you're familiar with what these various pieces of legislation and how they affect your company. Having said all that, there are specific types of companies that have even additional requirements. So I'm sure if you're in the food industry, you're well aware of all your licenses, your liquor licenses and your food and safety licenses and the permits you need to operate in certain towns and communities and cities. There's a whole bunch of things that you need to be aware of. And I've known a few kind of food establishments that didn't bother to check into this till after they were open, and they were quickly closed down. Or people opened these outdoor things in the summer and didn't realize there were regulations how to freeze their meat. And so check into all these things before you get started, or you might find that your seasonal business is going to quickly come to an end because you haven't thought about the things you should have. Pay attention. The food industry is heavily regulated, as you know. What are some other regulated things? I believe like the tourism, bed and breakfasts have some regulations. What else is regulated? I'm sure there's many other things. Have a look, be familiar with your own industry, make sure you're aware of what you can and cannot do. What are your most important assets, or who are your most important assets? For most of us, it's your employees. So again, from a legal perspective, treat your employees well. That's a human resources perspective. But a way to treat them well is to give them clarity, give them predictability. They might actually appreciate an employment contract that sets out what they can and cannot do, what their rights are on termination, what their vacation pay, what their perks are going to be, that type of thing. The skills of your employees is also very important. So I know this is not legal, but I can't help my business hat sometimes. Train them, teach them well. They will come back in spades to provide you with endless return on the money you invested in them. You also have tangible property. It could be a building you bought. It could be commercial kitchen things you bought. Could be your chairs and tables. Could be your camera. Could be your trucks and your vehicles. Protect them, for all the physicalness of them. Make sure you treat them well and have proper insurance on them. But what I really want to talk about for a minute are the intangibles. The rights that you've acquired, the permits you have to operate your fish farm or that type of thing. Make sure you have all those protected, renewed. You know what I would almost create a table of, if you have a lot of permits or things, when it's going to expire, what areas is for. Like, I would have all that clearly set out in my kind of organization of my company. What I really want to spend a few minutes on, because I can't resist and I think it's important, is to talk about intellectual property. You may or may not have intellectual property, but you may in the future have intellectual property, so it's nice to have a bit of knowledge about it. And this is the only thing I'm really going to say, besides a bit about trade secrets. And you create value in your IP. So your brand is intellectual property. Trademark is intellectual property. A copyright, your marketing material, your website, the content on your website, that's intellectual property, that's copyright. You might also come up with a brand new invention for doing something. You might not even think about it as proprietary or something that you might actually want to exploit and license to other people. But we're very handy, creative, crafty, innovative people in Newfoundland. And we come up with some really cool things. So should you protect that? That's a whole other conversation we can have if you want to invite me back. But in general, your intangibles are very valuable to your company. And more intellectual property is becoming valuable. So when I speak about IP, I speak about trademarks, copyrights, patents, industrial designs, and trade secrets, which I'm going to talk most about because I think that's the most relevant for you guys. But if you want value in your IP, you have to own it. Means that you have to make sure you don't infringe on anyone else's rights, that you are the sole owner, you're the creator, you have a unique right to it. That's the most important. And then if you can, you need to protect it. That could be filing a trademark or getting your common law rights protection. If it's a copyright, I'd love to see C in the circle and your company name on your website that shows the world this, you own the copyright to the wording on your website. So you have to protect it. If you have a patent, then we can talk about what it takes to file a patent if you're interested. And then you can own it and protect it. But if it has no value in the market, if it's not marketable, if you can't exploit it, it's still not necessarily a business asset. So whatever you're doing, you need to create the opportunity to exploit it. So you need your brand equity as a way of exploiting your trademark. Using your website to generate interest is a way of exploiting or getting commercial value out of your copyright. Selling your products, if you come up with a unique process in your kitchen, using that to your best advantage to be leaner or quicker or more efficient or fewer waste. Like, all these things are very valuable to you. Think about the things that you think are very valuable and that you consider your competitive advantage. What is it you do different from your competitors? What is it very unique to your company that you want to protect so that you make sure that it doesn't get in the hands of competitors or potential competitors? And we call those trade secrets. A trade secret is basically information that if it got out to the public or to your competitor, it would cause harm to your business. So these are things, it could be your customer list. Maybe you have a specific customer list and you don't want anyone else to know who that is. Maybe it's a pricing strategy. The way you price your product is different from anyone else's and it really works. You don't want anyone else to know how you do it. Maybe it's a secret recipe. Maybe it's great grandma's apple pie recipe and it's the talk of the region. And you don't want anyone else to know how that happens or how that works. Whatever it is for your company, think about how you're going to protect it. And there are lots of physical ways to protect it. So recipes, I often use this as one of my tests when I teach IP. That recipe, would you put it in a recipe book and leave it on the shelf for all your employees to see? No, you probably shouldn't do that. Should you lock it away with a lock and key and make sure one other person in the world knows where to find it if something happens to you? Yeah, that's probably more like what you should do with it. If they're valuable like that, you have to continually treat them as a trade secret because then they will continue to have value. But if you share that recipe book with all your employees and they take pictures of it and they go home and they start sharing that recipe with their friends and they email it to 5 friends and so on, all of a sudden, no one needs to come to your restaurant anymore for great grandma's apple pie, do they? Because they can all make it at home. So make sure that you share things with kind of the circumstances or the environment of imposing confidence. You have to trust people. You might have your employees sign a non-disclosure agreement or make sure that they have confidentiality requirements in their contracts. And employees generally do have an obligation of confidentiality, but I still wouldn't put things out in public for them to see. And I always use the Coca-Cola commercial or Coca-Cola recipe. And anyone who's heard me talk about Coca-Cola knows I'm a big fan. But I've moved on. You'll be happy to know. I now talk about Guinness because I saw it on a TV show, and it's a much more interesting example. This is one of these shows, how it's made, that I saw on Discovery Channel or something, and it goes through the process of taking the beer through the malts or whatever. I don't know anything about making beer. Anyway, at the very end of the presentation of the show, they go down this alleyway and there's all these red sirens and there's all these chain link fences and this big steel door, and you got to use your eye to be able to log in. You know, they have all this biometric stuff. And the guy doing the interview says, "What's behind that door?" And he says, "Well, I can't tell you. That's the secret ingredient to Guinness." And the guy says, "Well, let's go have a look." No. And he proceeds to tell him that there's only 2 people or 3 people in the world that have access to this room where the secret ingredient is kept. None of the employees ever see it. It's never known. And this is what makes Guinness Guinness. So that's the story of great lengths that someone has gone to protect this one ingredient, whatever it is. But you can imagine how valuable that one ingredient is to that company. So think about the physical protections that you need, in addition to passwords or, access points, keys and drawers and whatever it is. Think about ways that you're going to keep your most important secrets a secret from the rest of the world. And that's a big deal. The biggest deal with small companies who can't afford other means of protection. But everyone can afford to keep something a secret. All right, we're getting to the end. Who will you contract with? So I'm thinking you might lease space. If you're an event planner, you should enter into a rental agreement and decide who's liable for what. Your customers, again, if you're running a restaurant, you might not want to do that. I think there's a general rule. If someone comes into a restaurant, they expect to be safe. They expect to not fall. They expect to not be poisoned. I mean, I don't know that there's anything you can contract out of if someone comes into your restaurant. You just have to be very careful. Your suppliers, you may need things delivered at a certain time, within a certain time frame. You might want to make them liable if they don't deliver when they're supposed to deliver. You may not agree to that, but these are things that you could think about. Do you have your website? Are you using a third party for that Square? Who's your third party provider for e-commerce? Who's hosting your website? Do you have agreements with them? Do you need agreements with them? Do you have any investors? Could be friends and family loaning you money. Do you have contracts in place with them? Your business partners, that's your shareholder agreements or your partnership agreements. Do you have accountants or bookkeepers? What are your arrangements with them? I guess my point is there are all kinds of agreements that you're entering into. Whether or not you put them in writing, they're still agreements. They're oral agreements and they're equally binding. The problem with the oral agreements is that they're hard to prove. There's nothing in writing, so it becomes a he said, she said type of thing if you get into an argument. And those are really hard to win. So we always recommend as lawyers getting things in writing. It creates predictability, clarity, and everybody knows where they stand. And that's not a trust issue, that's just good business. So I really encourage you to form a relationship with your lawyer, get very acquainted with the lawyer, what they can and cannot do for you, and make sure the lawyer becomes acquainted with you and your business needs. And that relationship will see you through a lot of hard times and some good times, but the relationship is very important. Set out upfront how much they're going to charge you. Ask for quotes, ask for fees, tell them there's a limit. Whatever you need to do for transparency when you're dealing with your lawyer, you should do. Because everyone's afraid of the unknown big bad bill at the end. And if you strike that relationship and say, I'm a small business owner and I only have this much money, so do what you can for this much, or if you go over this much, tell me first, or can you do it for a flat fee, or can I pay you off over time? Like, try to strike whatever kind of arrangement you need. Most lawyers are not that difficult to deal with. There are some, but there are some in every industry. I just wouldn't discount the importance of having them, because you will need them from time to time. A couple things, keeping track of everything. If you have papers everywhere and you have if you've incorporated or you have a partnership agreement, where is it? I don't know. It's very important to keep these things together for tax reasons, for succession planning, if you ever want to sell your business to someone else. For whatever reason, you might be in a lawsuit and you have to go back and find minutes from a meeting. Keep everything organized. A lot of companies now are scanning things and kind of having electronic minute books, which is basically all your legal stuff in one folder, which is fine. At least you know where it is. The more traditional way is to have a minute book, which is something you could make yourself. Keep all your constating documents for your company, your articles, your bylaws, shareholders agreements, any shares that you have. If you've transferred shares, sold shares, issued shares, keep everything together. If and when you go to sell your company, that might be your retirement plan. Having all these things kept together over the years will make the transfer and the due diligence of the sale so much more efficient, and people will have much more trust that you know exactly what you're selling. So keep track of all those things. And if you're a new company starting that early and getting into that kind of routine, it will definitely serve you well. All right, I think this might be it. Might be one more. Who will take care of you in your business? You will. Even though I've gone on and on about getting a lawyer, you can be your absolute best advocate in your business. Knowledge is power, without a doubt, and the same is for law. You've probably already learned all about how to do your own financials. You've probably learned all about the permits you need. You've probably learned all about how to do your own marketing. But how many of you have actually learned about the law and how it applies to your business? We're kind of left out as lawyers, right? Because it's seen as doesn't affect me, or it's too complicated, or whatever it is. But there's so many things you could learn yourself. There's so much information out there. The more you know, the more sophisticated you're going to be when you go to a lawyer. You'll also have a better idea of knowing when you need a lawyer and what you can handle yourself. So don't be afraid to learn all you can about the legal aspects of your own business. It will serve you very well. It will help you deal with lawyers. It will help you deal with things yourself. When you go to a lawyer, they don't always take the time to explain everything to you. One, because they're busy, but two, they don't want to spend your money trying to explain everything to you, and they may assume you know things you don't. So don't be afraid to be your best advocate. Okay, any questions? We have, I see 10 minutes. Is that about right? We said 2 hours, so we did pretty good. Ken, ask me a question. Let me know you're alive.
Yeah, that was really informative. It was a really informative discussion. I think if it was like me, they were just carefully listening and sort of learning as we go. But yeah, I mean, you know the region, you know what people are, the kind of people are on here. If you were to pick something out as one piece of advice for everybody, what would you highlight from a legal perspective?
I know as a lawyer who deals with small businesses every day, I can help you the best when you've learned as much as you can before you come see me. And I'm here to advise you, and I'm here to teach you, and I'm here to help you. But when you come to your lawyers with a level of sophistication, the conversation can be so much more beneficial to you. So that's why I save that piece for last. Really, really, really take time to understand what you're doing and what your legal needs are. It'll save you a lot of headache and a lot of trouble, but it also makes the exchange of information so much more useful when you get it. It's not so overwhelming. It's not so intimidating. Please reach out to me. I believe Mary put my email in there. And check out our website. We talk about bringing on partners, what to look for, business partner. We talk about doing pitch decks. We talk about how to get investments. We talk about director's liability, kinds of stuff on our website for clients. So please, it's all free information. And there's a zillion websites like mine. So I'm certainly not the be all to end all, but feel free to check it out.
Thank you so much, Jacqui, and thank you to everybody who joined us today. Thank you, Ken, for suggesting Jacqui's name to do this session today.